A very good evening to all my dear students. I welcome all of you on behalf of ICAI for this wonderful session of Companies Act Chapter 3, that is Prospectus and Allotment of Securities. I hope the feelings are mutual. You are equally excited as I am today to teach you about this topic. But my humble request, I want all of you to sit ready with your pens, papers, because we are going to write n number of things along with your study material module. I want you all to pay full attention towards this lecture. So it's a very technical topic, children, but we'll try to make it as simple as possible so that you can learn it then and there in the class itself. So I hope you all are geared up for today's session. And with this welcome note, let me just say good evening to all those students who are here with us. Good evening, Tejaswin, Pranav, Tanu, Pallavi, Divya. Good evening, all of you and the students over here. Akram, Manvi, Rashmi, Subhashri, all of you, Hardik, a very good evening to all of you, dear students. So I hope you have done by now your preliminary chapter 1. You have finished your incorporation. And now we're going to start with chapter number 3 of Companies Act, that is Prospectus and Allotment of Securities. So as the name itself suggests, prospectus and allotment. Before we begin this session, let me give you a small overview of this chapter, what all this chapter is involved about. So the moment you hear about the word prospectus, that means obviously we are in Companies Act, we are talking something related to a company. So let me just tell you there are different forms of organization which you have learned in your CA foundation also. When I'm a sole proprietor, I'm an individual who is doing a business. Remember, when I felt burden, I need somebody to share my burden, to bringing in the joint capital and sharing the burden of business with me. I entered into a partnership. But what was the fault of the partnership? Unlimited liability. Both of us had to bear the torture of unlimited liability. Profits were getting divided. We were earning good things. We were having mutual agency. But unlimited liability was taken care by which form of organization? Can you tell me? Which another form of organization? You can answer me on the portal because I can see your answers over there. Good evening, Ranjita, Praveen, Neha, Asta, Tambeshwari, all of you, those who have just joined. And excellent, Tejaswin is the first one to answer it. Then we move to LLP, that is Limited Liability Partnership. Okay, many others have answered the same, so that's great. Now, after LLP, I decided to expand my business beyond that. I want public to invest money in my business. I want to take the shares. I want to invite the public to take shares of my company. What do you call that type of company? So I decided to move from LLP. Now I want money from the public. So I decided to form a company. So companies can be of two types. One is private company. One is public company. So here I'm talking first about the public company. When public company goes and asks money from the public, needs certain document on the basis of which I will be requesting the public to please come and take the shares in my company. That very document on the basis of which I'm going to make the issue of shares is known as prospectus. It's not just definition, it's just the introduction I'm giving you, children. There's a lot of things we are going to learn about how the prospectus is issued, how it is made. But just to give you the prospectus introduction, that is the where term prospectus will be used by a public company, and public company will be making a public issue as well as private placement. However, what is the definition of private company? Before we begin further, I want to take a small test of yours. You have to give me the definition of what is a private company. So there were 3 important points that we have done in the definition of private company. What is that private company? Number 1, it limits its members to 200. It restricts the transfer of shares, and it prohibits any invitation to the public to subscribe for securities. So that is the basic prohibition of a private company. So it cannot go to the public asking for the issue of securities. The moment it goes to the public, it becomes a public company. So it is only the public company which can go and have an IPO, FPO, which I'm just going to explain you in a while. A public company can go to the public asking to issue for the shares. Private company always goes for a private placement. So let me see how many of you have given the correct definition. Private company cannot. Vidushi, very good. Neha, very good. Rashmi, restricting the transfer shares, restricting, limit the number of members. Tanu is writing 200. And Ranjita has also written prohibition of inviting to invest from the public. So excellent. So we are all on the same page. You understand that private company cannot go to the public asking for the securities. So this is what we are going to do in this chapter. This chapter is divided into two different parts. The first part talks about the total sections that we are having over here is section 23 to section 42. Now, section 23 to 41 typically talks about your public offer. How we are going to issue the prospectus, what will be the contents of the prospectus, what all matters are to be included. If I include any wrong thing or misleading statements, what will be my liability as a director? Will the company be punished if it issues a wrong information in the prospectus? That is the misstatement in prospectus. Liabilities, what liabilities will occur? And all this process of public offer is explained under section 23 to section 41. And the second part of the chapter is private placement, which specifically tells you that a private company can only go for a private placement. Although public company also have this option, but private company has a fewer options, which I'm just going to explain you in section 23 very soon. So what all chapters overview is that we will be doing issue of prospectus. Section 23 is going to tell you how the securities are issued to the public. Section 26 is going to tell you what will be my contents of the prospectus, how the prospectus is going to be issued, what all is to be included in the prospectus. Section 29 is going to tell you about the dematerialization of the securities, that the securities have to be in demat form. And then so on, we'll be doing 31, 33, 25. There are various types of prospectus in this chapter. It is a shelf prospectus, red herring prospectus, abridged prospectus, deemed prospectus. But we'll be moving along with the sections so that the chapter becomes very simpler for you. I'll be following the ICAI module along with my presentation. So I try to complete section 23 to section 30 in today's class. So we'll be doing it section-wise. Otherwise, if you ask me, section 25, why they have given it like this? Because it is a part of type of prospectus. So when you do shelf prospectus, abridged prospectus, red herring, section 25 is deemed prospectus. It is a type of prospectus. But since we are flowing through the same sections, 23, 24, 25, so we'll be covering section 25 in today's class, section 28 and section 27. So 23, 24, 25, 26, 27, 28, 29. We'll try our best to cover these sections in today's first class of prospectus and allotment of securities. After that, doing the types of prospectus, we'll be moving to section 39, that is allotment of securities. Now, what is basically this chapter divided into? First, the company will go to the public that, look, I'm coming with my issue of shares. I'm coming with the initial public offer, that is IPO. I'll make you write down all these abbreviations and points and their definition as well. But as of now, just listen to me what I'm trying to tell you. So there is a company which is going to the public, issuing a prospectus telling all the information about the company, all the in and out about the company, my financial position, my net worth is this, I'm earning this much profits, making big promises. This is how I'm going to invest your money. And on the basis of this information document that the company has given, applicants will be coming to take up these shares in a company. So this prospectus is an invitation to offer. Remember, when you did Indian Contract Act, we have told you at that time that prospectus is an invitation to offer. We are going to the public, inviting them to subscribe the securities. So when we make the invitation to offer, applications will be received from the shareholders. That is the offer which the company is receiving. And how does the company make the acceptance? Company accept these applications. They will scrutinize these applications. Whichever applications they want to accept, they will allot these securities to those shareholders. So by accepting the applications and allotment of securities, the acceptance is given. A contract, valid contract is formed between the company and the shareholders. You will understand in section 39 how the allotment of securities is happening, how we're going to allot the securities. After this chapter talks huge about penalties. So you have to, yes, you have to learn the penalties. There is no escape route. You ask me about forms. I keep telling you there are very less number of forms in this chapter. Keep writing it down as in when I'm mentioning about the forms, because children in MCQs, these kind of things can come. And when we keep on repetitively talking about the same forms, same penalties, automatically you start remembering. But what is the thumb rule for remembering the penalties? I would like to tell you. Excuse me, sir, there's a lot of disturbance. Any issue? Am I audible? All right, can I continue? I hope I'm audible, students.
Yeah, you are audible.
All right. Okay. So that is how we have to allot these securities, and then penalties. I was telling you, I'm going to give you a small tip about penalties. What you can do is, in every chapter, whenever you read about the penalties, keep writing it down on a separate sheet and try sticking that sheet on the beginning of the chapter, so that whenever you sit for revising, doing revision of that particular chapter, you have specifically noted down the penalties. So all the forms and penalties, you can separately write it down in the beginning of the chapter, so that it helps you in doing a quick reference revision when you sit for your final revision. As of now, you might feel there is too much information. Again, the penalty is coming, ma'am, but I'm finding it difficult. Again, a form number has come. So it's natural. Let's accept it. It happens. It happens with everyone. Even when I was a student at your place, even I used to feel very tense. So many forms, so many penalties. But then we have to find a remedy. Then we have to find a solution to it. So this is a solution. Keep writing it down on a separate piece of paper. And the day you're revising it, things will come to your mind automatically, because you have written it in your own hands. All right. And after that, section 42 will be talking about your private placement, how the private placement takes place. We will discuss in detail about section 42. There is another section 40 and 41 where we'll be talking about the global depository receipts also. So when we move to that sections, we will discuss in detail about it. All right. So now, issue of securities. So I just told you what is the meaning of public offer. When the capital is raised from the public at large. So I'm going to the public at large and I'm asking, please come and invest shares in my company. So that is what I'm making a public offer. There are different methods of doing that, but when I go to the market, I go to the public at large, I make a public offer. And when I'm not going to a public offer, I'm going to a selected group of people. So I've decided I'm just writing a letter to these 3-4 people. I have written it's a private and confidential. Then only these people are issuing securities. I'm issuing securities. Only these people I'm inviting money from these kind of people. Then it is a private placement of securities. I'm just issuing my securities to a selected group of people. Then I'm not going to the public. So this is a private placement of securities. But when I do a public offer, I do an advertisement in the newspaper, or I'm making a notice, public notice, then it has to be done as per the applicable provisions of the Companies Act. So I just told you, then I will receive the applications, I will allot the shares, applicants will come and subscribe to the securities on the basis of the ad that the company has given, and allotment of securities as per section 29 will happen. The securities which are listed on an appropriate segment of the recognized stock exchange. So it is talking about the listed securities. Whatever securities have been listed on recognized stock exchange, they have to follow a bigger body, that is SEBI. Securities and Exchange Board of India regulations have to be complied for the listed companies whenever they come up with their IPO and issue of securities. So now starting with the first section, that is public offer and private placement. What is this public offer, ma'am? You have been telling us that public company is going to the public and asking for the securities. How this is going to happen? So the first thing that the company is going to do is, when for the very first time company is coming up, it will come with an IPO, that is initial public offer. Initial public offer means when for the very first time company is coming out with their shares, they want public to subscribe to their securities, that is known as initial public offer. When the prospectus is issued for the very first time to the public, you are taking out, for example, we recently had the Paytm prospectus, Nika prospectus. So I'll be showing you after the break, I'll show you some copies of the prospectus also, how the date is written, what is the book building written over there, how the prospectus actually looks like. I'll be showing you the physical, this soft copies of the prospectus as well. And once the securities are already listed, once the IPO has come up, now the company is again in need of money. So then it comes up with the FPO, that is further public offer. We come up with the further public offer. And the third type of public offer is OFS, that is offer for sale of securities to the public by an existing shareholders through the issue of prospectus. Now, what is the meaning of OFS? Although in section 28, we will be discussing in detail about OFS, but OFS means the shareholders or promoters of the company are selling their securities. The existing shareholders are asking the company to sell their shares in the market. So we are not bringing in the new shares. The capital is not increasing. Only the shareholding pattern is changing. Are you understanding? In IPO, I am coming up with the new shares. In FPO, I am coming up with the new shares. But in OFS, existing shareholders or the promoters of the company, they are allowing the company to sell their own shares to the public, that is OFS. So I would like you to, all of you, write down certain things about IPO and FPO. So what is IPO? I will just dictate you certain points about IPO. IPO means first time, all of you should write down, first time the company is issuing the prospectus, offering the shares to the public, offering the shares to the public through stock exchange for the first time. So IPO means for the first time, company is offering their shares to the public. Offering of shares to the public. So you're getting listed on the stock exchange. So through stock exchange, first time you're offering the shares to the public, that is IPO. What is FPO? FPO, children, write down further issue of shares to the public, which have already been listed on the stock exchange. So for FPO, you can write down further issue of shares to the public by a company which has already listed on stock exchange and has gone through the IPO process. So it is also known as subsequent issue of shares to the public. So for FPO, you have written subsequent issue of shares to the public. You have already listed on stock exchange, and now you further the company is in need of money and they are bringing in new shares are being issued to the public. The same company bringing a FPO. For the first time when you bring an IPO. Further you need the shares, you bring in FPO. Clear? Now what is OFS? OFS is a mechanism. OFS is a mechanism by which the promoters or the existing shareholders of listed company are trying to sell their shares directly through the company. So what is happening here? I've already written existing shareholders or promoters. It is a mechanism through which the existing shareholders of the company are trying to sell their shares directly to the public. All right. So here There is no fresh capital being introduced in OFS. Only the shareholding pattern is changed. Another fourth, now these three are the public offer methods, IPO, FPO, and OFS. Another fourth way in which the company can raise the money is by way of rights issue. How can the company raise money? By way of rights issue or bonus issue. Now, what is the meaning of rights issue and bonus issue? Rights issue or bonus issue. So this is the first method, IPO. Then second is FPO. Third we have done is OFS. Fourth we are doing is rights issue or bonus issue. So these are your rights issue, means existing shareholders are given a chance to take the shares in the company. And in case the company is having a lot of accumulated profit, it tries to issue free bonus shares to its employees. So bonus shares and rights shares, when we do chapter number 4, share capital and debentures, there we will discuss in detail about how the right issue comes, how the renunciation of rights issue happen, how the bonus shares is given. But as of now, public company can raise money by way of rights issue or by way of bonuses. And the fifth method is by private placement. Private placement means when I'm not going to the public, I'm just going to select a group of people. I'm requesting them to take up my securities, to buy my shares. Then it is known as private. However, in case of private company, okay, again, question, MCQ question for you. Okay, Sheikh, just give me 1 minute. Let me complete section 23. Then I will listen to your query. For a private company, can a private company come up with the public offer? Can a private company go for IPO, FPO or OFS? Yes, ma'am, or no, ma'am? I want an answer for this. Can a private company come up with the IPO? Yes, Ms. Bhavna, that was correct that you have written. Okay, Divya, how the prospectus is issued at the time of FPO, we will discuss in the further sections. Tambeshwari, section 24, we are doing section 23 as of now. Yes, Mr. Nanda, rights issue will be issued with a consideration and free bonus shares are given, but that is your, exactly, bonus shares, giving free shares to the existing shareholders. Pallavi, Aditi, Rashmi, all of you are correct. So no is the correct answer. Private company can never go for the public offer. So you have already answered it correctly because private company has a definition that we did. It restricts, it prohibits the invitation to the public. So that is written, it is prohibiting, but the articles of association only put that prohibition on private company. That's why it's a private company. It becomes a public company if it goes up with the IPO. So private company can never ever go for the public offer. Excellent answers. Khushi, Tambeshwari, Akash, Amar, Mehek, Asta, Anirudh, Dipali, Kontapuredi, Nanda, Komal. Very good. Mr. Nanda, it's okay. You can send your queries over here only. Now we are having the queries directly on the portal only. Okay, don't worry if you can't type in Zoom. Yes, Anirudh, very good. Nothing to do with the public at large for private companies. Shruti, Gerald, Rashmi, Tanu, so many new students we have today. Dama, Tejaswin, Aditi, all of you are correct, child. All right. So now what is the option available to private company, ma'am? You straight away told us these three options are gone. So private company cannot bring IPO, private company cannot bring FPO, private company cannot have OFS. So how will the private company raise money? Number one, by private placement. That we will study in section 42. We are not going to do private placement today. What is private placement, ma'am? Section 42. Next lecture, whenever the turn will come, section 42, last section, we will do what is private placement. But as of now, private company can only raise money by private placement. And two more methods, by rights issue. Right issue it can do. You're not going to the public. Where are you going for the right issue? You're going to your existing shareholders. And for bonus shares, again, you're issuing free bonus shares to your shareholders. So you can go to the right issue, bonus issue, and private placement. These three methods, private company can issue securities. So we have very nicely done section 23, simplified. Section 23 says public company, private. Public company can raise money by IPO, FPO, OFS, right issue, bonus issue, private. Private company can raise money, right issue, bonus issue, and private placement. Is that clear? Yes, Mr. Sheikh, you wanted to ask something? So this is your summary of the chart. Issue of securities, public company. By issuing the prospectus, public offer is being made. So when is the prospectus required? So your answer to the question, somebody was asking for FPO. So IPO, you issue a prospectus. Further subsequent request for the public for subscribing the securities, you issue the prospectus. For OFS, you issue a deemed prospectus. So very big words. Every word will be simplified in as we keep on moving next in the chapter. So OFS section 28, I will explain you in detail what is OFS, how the company is selling, how the shareholder are selling the securities. They have an issuing house. They have a person intermediary through whom we are requesting to issue a document and help us to reach the public. So that issuing house will be issuing a document, and that document, which is again issued to the public for inviting them to take the shares in a company, will deem to be a prospectus. Okay, just an overview I have given, details I will take. So prospectus will be issued for IPO, FPO, OFS. Then we have private placement, rights issue and bonus. And however, private company only has 3: private placement, rights issue and bonus. Clear? Now let's start with the definitions. So only 2 definitions are given in this chapter. In fact, 3. Expert already you have done in chapter number 1, but we will be talking about the definition of expert also over here. So the first definition that we're going to do is security. What is the meaning of security? Do you really we needed this definition? Security means your shares and debentures. But since it is given in the module, elaborative list of things that are included has been given. So examiner can ask you for 2 marks or 4 marks. Explain what do you understand by security, or MCQ can come on this question. So I'll explain you the definition. Then I will tell you how MCQs can come up on securities definition. So let us do the first definition, security. Security has an inclusive list. It says, if you read in the study material, it says it's an inclusive list. Inclusive means there can be more things also added. So it's just a list of things that they have given, which are defined as securities. There can be more things to it as well. So securities includes, number 1, the terms that are very familiar to us. Shares, you all understand shares. We are issuing shares to the company. So we can use the word security, issue of securities, issue of shares is one and the same. Scrips. Now scrips is something when the shares are traded on stock exchange, they are used the word scrips. So scrips is another name given to the shares only. Stocks means when you have consolidated shares. So if you have taken up 100 shares for rupees 10 each, and you have taken one stock of 100 shares, say for example. So it is a consolidated group of shares. It is known as stocks. What is bonds? Bond is a promise to pay the money. Remember your articles of association when you did doctrine of indoor management. You have done a very important case law over there. So there you have this. There you have seen about these kind of things, that a bond were issued. Bank has issued a bond, a promise to for the company to repay the money. So it is a kind of borrowings. Okay, bonds and debentures are kind of borrowings that the company has taken. When you go to the chapter of share capital and debentures, you will be learning at length about how debentures are issued, section 71, 72, deposits, everything you will be learning about this in detail. Then debenture stock, other marketable securities. So there can be other marketable securities, whatever securities are traded on stock exchange, buying and selling on stock exchange is happening. They are also included under the definition of security. Another term, so all these terms are very familiar: shares, stocks, debentures, debenture stocks. Other marketable securities means you can market them, you can buy and sell them on the recognized stock exchange. Whatever securities you're buying and selling on stock exchange is known as securities. Another is derivatives. Derivatives means instead of contracts, instead of buying and selling the shares today, you are entering into contracts for buying and selling the shares in future dates. So derivative is your future purchase of sale of shares. So today I'm entering into the contracts for buying and selling the shares in future. Part of your CA final financial management skills. There you will be learning in detail. Debentures and bonds, shares, you will be learning in here now in chapter 4 only. But for derivatives, you have to wait till CA final. There you will learn in detail. Abhi ke liye what to remember? Derivative is part of securities. That's it. It is some future purchase and sale of shares that is going to happen in the stock market. Units of collective investment scheme. So there is a collective investment scheme. So if examiner can ask you an MCQ, the units of collective investment scheme, is it a part of security? Yes or no? Tell me. If I ask you, there are units of collective investment scheme. Is it a part of securities? Miss Gurminder Kaur, FPO and Tameshwari, we will be discussing abhi FPO, IPO again when we move to section 25, 26, 27. So don't worry. FPO simply means further public offer. The company has already issued an IPO. They have already listed their shares on stock exchange. Now the company is in need of more money. So now it is further issuing a prospectus and again requesting the public to take up their shares in the company. That is the meaning of FP. How it does it? Section 21 will explain you about the prospectus. Yes, Tejaswin, NSDL and CDSL are depositories, but here we are not talking about depositories. When we go to section 29, then you can talk about them. Derivatives are futures and forward contracts. Very good. Bhavna, scripts is another name given to shares. So shares and scripts it is basically a word used for trading on the stock exchange. So scripts, you can say it is a word used for share when it is listed on the stock exchange and traded. You know what is the meaning of trade? Trade means buying and selling the shares on the stock exchange. All right. Okay. So any other query? Mutual funds. Okay, I'll be explaining you mutual fund. Yes, it is part of security. So collective investment scheme, I just asked you whether it comes under definition of security. So you will say, yes, it is part of security. Again, securities, security receipt, which is defined under securitization and reconstruction of financial assets and enforcement of Security Interest Act. So this is also part of your security. I will show you this definition and the MCQ from study material also. So Vaishnavi, bonds and debentures differences. When you go to chapter number 4, share capital and debentures, there you will understand what is the basic difference between bonds and debentures. As of now, bonds is a promise to repay money. It is a kind of a borrowing. Debentures is also a kind of borrowing that the company is asking from the banks or public to take up the debentures. So when we talk about existing shareholders, they will be existing debenture holders of the company. Okay, so it is a kind of a borrowing. Also, you can refer to the debentures definition that we have done in chapter 1. It is debentures is an instrument used for evidencing debt. All right, remember debt means something which we have to pay back. The company has to pay back that money. Another interesting thing is, now this is something important, units of mutual funds. So mutual fund you're investing, that is also security. But ULIPs are not part of security. Now here where the MCQ will come. So he will ask you, mutual funds are part of securities? Yes, ma'am. ULIPs are also part of securities? No, ma'am. ULIPs are unit linked insurance plans. So at times companies are offering your securities are being given to you in which they ask you that invest and we will give you dividend in return. And also they have the life insurance plan. So there is a kind of investment that you do in the market where you take up ULIPs. So ULIP is your mutual funds also. You're getting the return for mutual funds on the investment. Along with that, you're paying for your life insurance cover also. So since your life insurance benefits are being covered over here, so that is excluded from the definition of security. So if I ask you, ULIPs is part of securities definition. Yes, ma'am. No, ma'am. Yes, Ms. Bhavna, only IPO will come for the very first time when the company is incorporated, not at the time of incorporation, at the time when it is offering the shares to the public. After that, whenever it issues the shares, it will come up with the FP. That is correct. Yes, all those mid-cap funds, long-term funds, Ranjita. So Pranav, mutual funds, where you are investing the money and you're getting return on it, that is your mutual fund schemes, different mutual fund schemes. You don't have to go into much detail. Just remember, mutual fund scheme is also part of securities, but ULIPs are not. So no, ma'am, all those who have given ULIPs are not. That is absolutely correct. Okay. Let's move further. There's certain more things in this. Then the certificate or instrument issued to an investor by an issuer, government securities. So if I ask you government, any certificates of investors, any government securities, any other instruments as declared by central government. Done. Finish. Anything central government can declare. So any other instrument means everything will come. Whatever CG will say tomorrow that, listen, ma'am, this is also part of security, that will also become part of security. Any other instrument that declared by central government. But you as a student have to learn all these points. Okay. And rights or interest in securities. So let's quickly have a recap. Securities means shares, scrips, bonds, stocks, debentures, debenture stocks. All these are similar kind of words. ऐसे याद रख लेना कि shares and debentures, chapter number 4. So all those categories, shares, bonds, scrips, debenture stocks. One category. Derivatives are see a final kind of syllabus, futures, forward options. So derivatives is over there. Collective investment scheme, security receipt under this particular act that they have mentioned, you have to memorize it. Mutual fund scheme is important. ULIPs are excluded. Mutual funds are also securities. Then your certificate and instrument issued by the investor under the special distinct entity. Government securities is very easy to remember. Any other securities which is declared by central government, and your rights or interest in securities is also securities. Finish. We'll do these two definitions, then I'll take you to the study material. Okay. Now, what is prospectus? Securities definition is clear, simple. We have to learn it. Prospectus means any document. First, I will read out to you what section 2, clause 70 says. Any document described or issued as a prospectus means any document through which you are going to the public and asking, please come and take my shares. So you are a company, XYZ company. You went to the public and you said, this is my document, this is my financials net worth, please come and take my shares. I'm a very nice company. I'm going to invest your money over here. This is my financial position. Whatever document, you can see in the picture also. Any document which is described or issued as a prospectus is prospectus. Means you are using that document for inviting the shares from the public, issue of securities from the public, issue of securities to the public. That document is a prospectus. And it includes red herring prospectus under section 32, shelf prospectus under section 31. Any notice or document, circular, advertisement where you're inviting the offers from the public to come and purchase the securities of your company, that document is known as prospectus. Now, what is this? So much information. How will we remember? Let's break it into different parts. So let's go to this slide number. Prospectus means. So it says number 1, what is the meaning? So how are we going to learn it? We're going to divide it into different points. Number 1 point, any document which is described and issued as a prospectus. I just explained you, I take a document inviting the public to come and take the shares of my company. That document is a prospectus. And it includes shelf prospectus. Now, what is shelf prospectus? You never told us because it is yet to come. Section 31. These are basically types of prospectus, which is there in the definition also. So, shelf prospectus means a prospectus. Red herring prospectus means a prospectus. They should have written abridged also. Abridged is the summary of the prospectus. Okay. And 4th is any advertisement, any circular. So, there is a company, XYZ company. It gave a notice in the newspaper, or it gave a circular, or any advertisement which is inviting offers from the public. So I'm a company, XYZ company. I've given a notice in the newspaper that I want public to come and take the shares in my company. That advertisement is also a prospectus. So when you issue section 31, 32, red herring or shelf prospectus, we have not yet done, but that is a prospectus. What are they? We will do it in further chapters, further sections. Any advertisement where you're inviting the public to take the shares in your company, that is a prospectus. And any document described, koi bhi document through which you go to the public and you ask them to come and take the shares is known as prospectus. So how do we have to learn it? Number 1, prospectus means any document which is described and issued as a prospectus. It includes shelf prospectus and red herring prospectus and any document, notice, circular, advertisement by which you're offering shares, offering the public, inviting the offers from the public. Inviting offers from the public means you're requesting the public to please come and take the shares of my company. You're attracting them. Please, my company is doing so well. Why don't you come and take the shares? You're asking money from the public, basically. Jahan se I started the lecture. Public company is now going to the public and asking the public to please give me some money. I want to expand my business. So for that, it is issuing a prospectus and inviting the offers from the public. So when the public will come and give you applications, that is offer, you allot the securities, you give the acceptance. Clear? Definition of prospectus. All right. So this is how your prospectus looks. So these are different types of prospectus. Red herring prospectus, book building prospectus, shelf prospectus. So all these types of prospectus we'll be covering in further sections. One small section 24, what is it trying to tell you? That listen, my dear, SEBI is going to regulate your issue and transfer of securities. So as of now, Companies Act was ruling us. We were following Companies Act provisions as well as the rules. We will be having number of rules also in this chapter, children. You have already been informed that whenever we are doing any act, there are certain rules related to that particular section also. Because whenever we want to bring any changes or any amendment, it is easier to bring those add-ons in the rules, companies' rules. Because in order to amend the entire section or act, you need to go through all that entire procedure of making the amendments, going to Rajya Sabha, Lok Sabha, and then taking a send from the president. All that entire procedure has to be followed. So we always try to follow companies' rules along with that, so that whenever amendments can be brought in, we can bring the changes. So whatever conditions have been given related to a particular section, we will be referring to the particular rules also along with the sections. Now, what is Section 24 is telling? Section 24 is simply telling you that so far there was Companies Act. Now another huge body, that is Security and Exchange Board of India, has come up. Since you're going to the public, you're becoming a listed company, SEBI has to be followed. So SEBI will regulate all the issue and transfer of securities. Whenever you are raising the issue of securities, whenever you're going to the public, how you will go to the public, how you'll ask them to subscribe the shares in a company, how the transfer of securities will happen, all this will be regulated by which body? Securities and Exchange Board of India. SEBI will regulate all these matters related to your non-payment of dividend by listed companies, for listed companies as well as the companies intended to get their securities listed. So all those companies which are already listed and for those which are intending to list their securities, SEBI will regulate your issue and transfer of securities. Number one, Section 24 is telling you this. Number two, it is telling you all other matters relating to prospectus, return of allotment, redemption of preference shares shall be taken care by central government, tribunal, or the registrar. What did it say? All other matters related to return of allotment, how the return of allotment of shares will happen, how the prospectus will be issued, how the redemption of preference shares will take place, shall be administered by central government, tribunal, or the registrar as the case may be. So the question the examiner has asked you, the power to administer the matters relating to redemption of preference shares by listed company. Will the SEBI will be taking care? Who will take care for redemption of preference shares? Tell me. You can see the answer there in front of you on the screen. Who will take care of redemption of preference shares? Asta, Mohammed Saklain, Vidushi, Maroju, Rashmi, Mehek, Faisal, Arun, all of you have given the correct answers for the previous one. Pranav, Vaishnavi, Akash, Preeti, Amar. Good children. So tell me, who will take care? SEBI is not going to administer this redemption of preference shares. Why? Because SEBI is going to regulate the issue and transfer of securities. Other matters related to prospectus, return of allotment, redemption of preference shares, specifically given in this act, will be administered by whom? Will be taken care by central government, tribunal, or registrar. All right. Thank you so much, Vidushi Jaiswal. She is writing that she's finding very easy all this presentation and the lecture. I'm so glad to read this, Vidushi. Thank you so much. Again, you are writing Contemporary SEBI. SEBI will not take care of this. Redemption of preference shares, other kind of things. Government, tribunal, and registrar will be taking. So that is how the MCQs can come. All right. Minute details which are given in the chapter, MCQs can come from. Yes, Archana, you wanted to ask something. Unmute yourself. Meanwhile, I'm opening the study material. Archana, you can speak. Yes, Archana. Can you speak now, Archana?
Yes, ma'am. My chat and my mute was disabled for a longer time, so I couldn't able to chat. That's why I raised my hand.
The chat is not allowed. You can now go to the portal for writing your queries. You can write
Okay.
your queries at the admin portal. Okay.
Okay, ma'am. Thank you.
All right. Yes, Sai Charan. Sai Charan.
Ma'am, good evening, ma'am. Why
Good
a
evening.
special reference was been given to only preferred shares, ma'am? Preferred shares,
Sorry, please
only
come
certain
again.
aspects. Why a special attention was given to redemption of preferred shares?
So it is just
That matter.
mentioning, okay. Redemption of preference shares is actually covered under your chapter number 4, share capital and debentures. You will discuss in detail how the redemption of preference shares is happening over there. It is just trying to tell you that certain other matters, including, means I'm just trying to tell you that matters like prospectus, redemption of preference shares, and other kind of things. So they're just giving you examples. And on the basis of same example, the study is going to give you an MCQ that this kind of thing, is SEBI taking care of it? So you will simply write false. Why? Because SEBI is basically regulating your issue and transfer of securities. Anything for the listed and the companies which are intent to list the securities, it is talking about that. All right. So it is a simple reference. I'm going to show you from the study material also the similar kind of topics.
Okay, ma'am. Then buyback of shares will be taken care of.
So buyback of shares, when you go to share capital and debentures, there I will explain you how it will happen. Okay, because there is not just redemption, there is buyback, there is sweat equity, there are DVRs, not many things in that chapter. Okay, but prospectus in itself is very huge. Since it's written over here, so I wanted to take it. All right. So children, you can see the chapter, what all we have covered from here. Section 23 to 42 deals with this chapter. We have talked about public offer, private placement. I hope everyone is now clear with section 23, subsection 1, how the public company can issue securities. Public offer includes initial public offer and FPO, securities or OFS. So I have explained you, we have written down in notes also what is IPO, what is FPO, what is OFS. And this is a very nice line. Further public is also known as fellow public offer, whereas OFS is sometimes called deemed public offer. So when I will be teaching you about section 25 and section 28, you can find some terms which I will be using sound similar. So OFS is sometimes called a deemed public offer. Private company, only right issue, bonus issue, and private placement. So if I ask you, public company can go for all the public offer. Private placement, yes, both of them can do. Rights issue, both of them can do. But private company cannot go for public offer. And does private company require the compliance with SEBI rules and regulations? Tell me, children. Private company has to follow the SEBI rules and regulations? Yes, ma'am, or no, ma'am? Only a listed company has to follow the SEBI rules and regulations. So it is a public company which gets its shares listed. You're not going for public offer, so private company is not required for the issue of securities. It is not required to comply with the SEBI rules and regulations. For a company which is listed or proposed to be listed, again, very important. Unlisted public company ke liye, there is no SEBI rules and regulations. Where are the SEBI rules and regulations? If you're getting your shares listed, either you have listed or you're proposing to list your shares. Then only you have to follow the SEBI rules and regulations. What are the SEBI rules and guidelines? They are not over there. These just trying to tell you that you have to follow and comply with the SEBI. So this we have done. Now this is your definition of securities. We have done it in detail. Only one important thing I wanted to show you, securities will not include unit-linked insurance policy or scripts by whatever name is called, because it is a combined benefit given. So ULIPs, it is giving you two benefits. One is your investment, one is your life insurance. They are not included in part of your securities. Okay. So your it says Indian companies have the access to overseas equity markets through depository receipts. So your ADRs and GDRs are also part of this chapter, section number 40-41, where we'll be talking about the GDRs. Simply, he's trying to tell you over here that since people are going global and the capital is being raised from outside, section 23, subsection 3. Remember when I taught you about listed companies definition, there a term was used if your shares are listed under section 23, subsection 3. I told you it talks about foreign jurisdiction. If you can recall, children, in chapter number 1, preliminary listed companies definition. Here it is written. I tried opening in that day also. I was trying to show you. Here it is written. It basically tells you the companies which are notified, they can raise their they can raise their shares in the foreign jurisdiction. Basically, they can have the overseas direct listing also. Which companies? Only the notified public companies. So you're trying to expand your business, you're trying to get global, you want to bring the capital across the borders, then section 23 subsection 3 has been inserted. It talks about overseas listing. So here only the companies which are notified class of public companies are permitted to raise their shares on the foreign jurisdiction as well. This much line is only written over here. So you can simply remember there are certain public companies. You can write it down briefly also. Please write down over here. I'm making you write a small note. Certain public companies which have been notified can list their shares in the foreign jurisdiction. Only the notified public companies can list their shares in the foreign listing or overseas listing. Can list their shares in the foreign jurisdiction means overseas listing or foreign listing is allowed. For any other companies, in case of any other companies, GDRs have to be issued. For any other companies, GDRs have to be issued in case they want the investment from the foreign. In case they want the investment from the foreign, GDRs can be issued, which is covered under section 41. Simple. बस इतनी सी लाइन थी ये बताने वाली that there are certain notified companies which can go for overseas direct listing, but for any other companies, GDRs can be issued. GDRs will be covering in section 41. How overseas is listing from ADRs and GDRs? Again, section 41, we will talk in detail about GDRs. So here he is trying to tell you that how the division of this chapter is happening. Here we are talking about prospectus and allotment. Then we will be talking about share capital and debentures, declaration of dividend. All these are related chapters. Central government has power to exempt any class of companies. So section 23, subsection 4 says, central government has the power that these are the different chapters which we'll be doing for public companies, but certain public companies can be exempted only if CG tells them that you don't need to follow these sections, then they can avoid these sections. Basically, these chapters. All right. So let's have this small MCQ given over here. So we have just discussed this. Section 23, subsection 3 talks about your public company. So Bear Act extract is written over here. I've just made it simplified for you that certain companies have been notified which are permissible to trade their shares in foreign jurisdiction, and central government has exempted certain class of companies from following the provisions of all these particular sections. Okay. Which of the following shall not be considered as securities? Unit-linked insurance policy, actionable claim regarding mortgage debt, securities issued by National Asset Reconstruction Limited. Is it only the third option, or first and third option, or second and third option? Tell me the correct answer, children. Which of them shall be considered as securities for the purpose of section 23? Which is the correct answer? Actionable claim regarding mortgage debt. Let me see how many of you are giving the correct answer. Don't worry, Mahima. We will discuss at the end about how to go for the notes and revisions. As of now, just keep paying attention. Thank you, Ms. Tanu. I'm glad you're finding the concept easy now. Finding prospectus easy is something really great. Miss Maruju, all the MCQs and direct topics, case studies, I will tell you in detail later on how the MCQs. I have planned a session in which specifically we'll be discussing about the question paper questions only. There we will talk in detail about MCQs and other things. Aditi, I hope now section 23, clause 3 and 4 is clear to you. Very good. So all of you have given the correct answer. Option C is the correct answer. Specifically is trying to tell you that ULIP is not to be included. Actionable claims and other securities issued by National Asset Reconstruction are included in the definition of securities. And this is your section 24, which we have just discussed. So the matters, powers given to this, false, why it has written, because he has only told you all the companies which are listed and going to list on the stock exchange. All those matters SEBI is going to regulate. Is that clear, children? Now we have also done the definition of prospectus. So this is what I wanted to show you from the study material. Now we are going to talk about deemed prospectus, the document containing the offer of securities for sale. I will just brief you about deemed prospectus and then I'll take a small break and then we will discuss in detail. So what is the meaning of deemed prospectus? Whenever the company is going to allot its securities to the public, certain time it needs certain issuing house or underwriters. They try to make an arrangement. It is very difficult. The company is trying. I just explained you there is a very bigger body that is SEBI. So there is a bigger body, SEBI. SEBI has its own rules and regulations, which has to be complied by the public company whenever it is going for listing its securities, whenever it is coming up with an IPO. So the company thinks that, okay, let me go to the issuing house. I will tell them to publish a document on my behalf. And why don't this issuing house goes and tells the public that we are offering the securities to you. Please take and go and take the money from the public. Now, what this issuing house is going to do, suppose there is a company XYZ company. It will go to the issuing house. Now, issuing house will go to the public and they will issue a document that please come and take up the shares of this company XYZ. Now, law says, although you are trying to escape from following the SEBI rules and regulations and all these Companies Act provisions, that's why you have not issued a prospectus. But this mediator, intermediary party, the issuing house, who is on your behalf going to the public and issuing the document, this document that they're going to issue is deemed to be a prospectus. That document will deemed to be a prospectus. It will be considered as if XYZ company has issued a prospectus to the public. And what will happen then? All the provision of section 26, that is contents of the prospectus, all the provisions of misstatement and liability. So what happens, children, if there is any misleading statement, if there is any false or suppressing material in the prospectus, then there is a very harsh liability for all the directors who are behind the company who are issuing this prospectus. So now you were trying to escape from all those liabilities. So law has made it mandatory that even if the issuing house is giving your offer of the securities to the public, then also that document shall deem to be the prospectus. And all the provisions of section 26, 27, your variations in prospectus, your liability, section 34, 35, misstatement liability will become applicable to this deemed prospectus also. So even though you tried to form an escape route, you still came under the deemed prospectus provision and the applicability of provisions will happen to you. So rules have been laid down along with the section 25, which will tell you how the signing of this prospectus, every director needs to sign the prospectus. But in case of a deemed prospectus, 2 directors need to sign. And if it is a firm which is acting as the intermediary party who is issuing the prospectus for you, then at least half of the partners needs to sign that prospectus. All right. So I'll show you from my presentation. I think let's take a small break over here and then in detail, we'll be talking about the deemed prospectus. I'll give some rest to my throat. Let's take a small break here. So let's move to the deemed prospectus. Section 23, 24 we have done. Section 25, I have given you the briefing of section 25, but let's discuss in detail about the deemed prospectus. So it says where the company allots or agrees to allot any of these securities. So what is the company doing? Company is allotting its securities to the public for offering for the sale to the public. And then here, see, for example, there is a company, XYZ company. There is an intermediary in between whom we call an issuing house. The company will go to this issuing house and will tell them that, look, this is the document which you can use for offering my shares to the public. OFS, offered for sale means OFS, so offering the shares for sale to the public. So this XYZ company will give all the details to the issuing house. This is my net worth, this is my financial position, everything. And the company will sell the shares to them and take the money from them. They'll just sell the shares to them and will tell them, this intermediary party, that when you sell these shares to the public, and as in when you receive the money, you give us the money. So if you have seen in a retail business also, there are distributors whom the distributors give the goods to the retailers and they tell them that you can sell them to the market and as and when you receive the money, you can give it to us. So same way company is using the issuing house and giving them a document, selling them the securities, requesting them to offer for sale to the public their securities. Now this issuing house will issue the document. This issuing house, what will this do? He is an intermediary between the public and the company. They will go and make an offer of securities to the public on the basis of the document. This document on the basis of which they are making the offer for sale to the public shall deem to be prospectus in all respects. We are just trying to protect the interest of the investors from any fraudulent practices. Basically, it says all the provisions of prospectus will become applicable the moment this issuing house issues the prospectus, this document, to the public for taking up the shares. But it says, subsection 2, number 1, the securities are offered to the public within 6 months of the allotment. So say, for example, on 1st October, XYZ company has made an agreement, 2023, XYZ company has made an agreement with the issuing house that we want you to take up this work and issue a document for the sale to the public. Now, within 6 months, October, November, December, Jan, Feb, March. So within these 6 months period, if the allotment of securities have happened, securities have been issued to the public, then it will be presumed that this document, the intention of this document was to go to the public. Otherwise, we can say that we have made a sale to the issuing house. Why are you calling us as a prospectus? So law says there are certain conditions which you have to see. You have to see what was the intention of XYZ company. The intention was to go to the public because within the 6 months, the agreement was made between the issuing house and the company. The allotment of securities have happened. That means the intention of the company was to go to the public only. So this document is presumed to be prospectus. Or we can say full consideration has not been received by the company from the date of offer of security. So the company has not received the full consideration. There's still certain amount which is pending. So if I have received the full consideration, then it is a normal buy and sell on the stock market. So I sold my shares to Mr. X. He gave me the money. So then it is over. Then it is not prospectus. I'm selling my shares. I'm trading my shares on stock exchange. But if I have not received the full consideration, that means my intention was to go to the public and we are waiting for the money to come from the public. So it is assumed. Section 25 says there are 2 presumptions which you have to follow in order to make sure to have been made with a view to offer means that you're offering them to the public. This has to be seen that these 2 things were over there. Then only this document shall deem to be the prospectus document. Is that clear? Okay, so what 2 things you have to see? Number 1 thing you have to see is that within the 6 months of the agreement between the issuing house and the company, allotment of securities have happened. Securities have been offered to the public within 6 months. Then it will be considered that this document which you have used shall deem to be a prospectus. Or full consideration has not been received from the date the offer has been made to the public. Then also we'll assume. Unless the contrary is proved. So you have to prove it contrary. If you don't want it to be a deemed prospectus, the company has to prove that these 2 points were not. If either of these points happen, it will deem to be prospectus. So it says if any of the 2 conditions is met, issuing document shall deem to be the prospectus under subsection 1. And what will happen? What is the effect of this deemed provision? All the provisions, now you cannot have any escape route. Now you have to follow whatever is written in the Companies Act. Section 26, contents of the prospectus. You have to make the prospectus according to section 21, 26 provisions, and all the liability provisions of section 34, 35 shall now apply to this deemed prospectus. Clear? Number 1, the point that we have done under subsection 1, that will be the first point. Those who are making notes side by side. Subsection 2 point will be your point number 2 for the notes. Effect of prospectus will be your point number 3, that now it becomes deemed prospectus. Section 26 and 34, 35 become applicable. Okay, now this is a small case law which has been given in the study material reference, SEBI versus Kunnakam Kulam Paper Mills Limited. It simply tells you where the right issue was made to the existing members with the right to re-announce in favor of another's and the number of members exceed 50. Then this document which was used for right issue also shall deem to be a prospectus. So simply there was a case law reference that has been given. It says there was a document, right issue was made to the existing shareholders. Here you're not going to the public. You're just asking existing shareholders to give money to the company and take up the shares in a company. So there was a right to re-announce in favor of others and the number exceeded 50. So it shall deem to be the prospectus if such kind of condition is existing between the company and the shareholders. Now, this is your point number 4. We have done 3 points in deemed prospectus, and this is the point number 4 that you have to remember. What are the matters to be stated? Additional matters. When it shall deem to be a prospectus, following matters need to be stated in addition to section 26. Section 26, we are going to start in a while after 25. Whatever is written under section 26 shall be included in deemed prospectus also. Additionally, these 3 things also have to be included when we talk about the deemed prospectus. What are those 3 things? A statement of the net amount received or to be received as consideration for the securities to which the offer relates. So how much amount has been received or has to be received for the sale of such shares? Time and place under which the underlying contract of allotment may be inspected. So the contract was made, I told you in the beginning the example, XYZ company made a contract to the issuing house. Issuing house is issuing the document for offering sale to the public. Whatever agreement was made between this, the contract that was made between the company and this issuing house, at what time and place this agreement can be inspected, this has to be included because this should be an open agreement in order to avoid any fraudulent practices, because investors, children, prospectus is very important. You have to understand the each and every point very carefully because see, public is investing money in your company on the basis of this document. You cannot do any kind of fraud or cheating. You are going to the public at large. So you're inviting subscriptions. You're asking public to invest money in your company. They're taking up the shares. So it has to be a relationship of trust. Everything has to be very clear and fair and transparent thing has to happen when you're issuing prospectus to the company. So the chance should be given for the inspection. Whatever agreement you have made with this issuing house, at what time and place this agreement can be inspected has to be included in the prospectus. And the persons making the offer will be named as directors of the company. So the issuing house, whosoever is making the prospectus, whosoever is making the offer will be named as directors of the company. They will become the directors. Whosoever will be issuing the prospectus, they will be presumed to be the directors of the company. So that means they become liable like directors. Along with section 26, section 34, 35 liability will also be applicable. If any wrong thing happens, if there is any misstatement, which we will understand in section 34 and 35, then these people who have signed the deemed prospectus shall be liable as directors of. Is that clear? So along with section 26, additional matters to be included in the prospectus are: number 1, net consideration received or to be received for such securities, sale of such securities. Number 2, the time and place where the contract between the company and the issuing house can be inspected. And the person who are making this offer, who are named in the prospectus, will be acting as the directors of the company. Is that clear? There's one more point. Point number 5, you can write down, those who are making the notes. This is your 5th point for deemed prospectus. If the document that is deemed prospectus through which you're offering the securities to the public is on behalf of company, it shall be signed by 2 directors. In case of partners, at least half of the partners shall be signed. So if you're issuing house, so this is a company, XYZ company. There is an issuing house. Now let's assume this issuing house is A Limited. So it's a company. Issuing house is a company, A Limited. How many directors shall be signing the document? If A Limited is the issuing house, how many directors shall be signing the deemed prospectus? Tell me. Mr. Tejaswin, all your overseas listing, when we talk about GDRs, we will clear everything over there. But as of now, yes, SEBI regulations have to be covered when you're talking about the listing of securities. Miss Tanu, what do you want me to explain in Hindi? You know, these lectures have to be taken up in English. If you have any doubt, you can ask me. I'll explain you in Hindi. Mr. Nanda, that was specifically for the right shares you're issuing and the members exceeding 50. Yes, then it will be a deemed prospectus. And Aditi and others re-announced right issues. Chapter number 4, they will discuss what are right issues and how the rights to renounce have to be done over there. Vidushi, excellent. So if you're taking 8 months of allotment, then it shall not deem to be prospectus. So within 6 months, if the allotment has happened, then only it shall deem to be a deemed prospectus. If you're taking any time beyond that, then yes, you have to prove that point contrary has to be proved. Then it shall not deem to be a prospectus. But the other condition also, if net consideration has not been received, again, you'll fall under the preview of prospectus. So very good. Tejaswin, Shruti, Tanu, Nanda, Pallavi, Rashmi, Divya, Arun, Damasai, Pala Murugan, Vidushi has given the correct answers. 2 directors will be signing if issuing houses A Limited. If issuing houses AB Associates, so there are 50 partners in AB Associates. How many partners shall be signing the deemed prospectus? If the issuing houses, Asta and Tanu asking about the summary of deemed prospectus, I'll explain you, asking in Hindi also. Okay, just let me complete and then I explain in Hindi. So if issuing houses ABC Associates, how many of them shall be signing? There are 50 partners. If 20 partners have signed, is it correct? MCQ for all of you. If there is a issuing house is having ABC Associates 50 partners and 20 partners have signed the deemed prospectus, is it okay? No, ma'am, at least 25 partners because half of the partners shall be signing. I hope it's clear now. So 5 points we have done so far in deemed prospectus, section 25. Okay, there is Nash versus Lynn case also. I'll take up this from the study material. Okay, this particular question from the study material because you have not yet done the damages, you have not done the misstatement, but still we'll understand the meaning of public. When I go to the study material, just remind me there is 1 point I'll take from there. But as of now, let's have a quick summary of section 25. So in Hindi, those who were asking, quick summary in Hindi, Tanu. अगर कंपनी को अपने शेयर्स पब्लिक के पास लेकर जाने हैं तो कंपनी इंटरमीडिएरी पार्टी के पास जाती है कि मैं सेबी की रेगुलेशन से बचने के लिए ऑल द प्रोस्पेक्टस के रूल्स एंड रेगुलेशन से बचने के लिए आपको रिक्वेस्ट कर रहा हूं कि आप पब्लिक को बोल दीजिए कि वो मेरे शेयर्स सब्सक्राइब. So law says the document that this company is giving to the issuing house, the agreement that they have made and the document which issuing house is giving to the public for sale of securities, that document shall deem to be prospectus. And once it is prospectus, all the provision of section 26, section 34, 35 will be applicable to this deemed prospectus. And what are the conditions to be seen in order to call this the prospectus? It says there are 2 presumptions, 2 presumptions hai. अगर allotment of securities हो जाती है within 6 months when this agreement was made between XYZ company की issuing house के साथ जब agreement हुआ उसके 6 months के अंदर अंदर अगर allotment of securities हो जाता है then this document will be a deemed prospectus. और आपने सारा का सारा पैसा means issuing house has received the money, have not received the full money from the public. So that means आपकी intention public के पास जाने की ही थी. आपने सिर्फ हमें use कराया एक document issuing house को देकर. Your basic intention was to go to the public only for the security. So it was deemed to be the prospectus. And additional matters, I told you, Hindi में section 26 के सारे matters तो आएंगे ही आएंगे. तीन चीजें एडिशनल आएंगी डीम प्रोस्पेक्टस में. एक ऐसी चीज कि कितना अमाउंट रिसीव हुआ है फ्रॉम द पब्लिक. टाइम एंड प्लेस मींस ऐसी जगह जहां पे आपका एग्रीमेंट जो बना है कंपनी का एंड दिस इशुइंग हाउस वेयर दैट कैन बी इंस्पेक्टेड मींस उसे कहाँ रिव्यू करा जा सकता है. एंड जिन लोगों ने इस प्रोस्पेक्टस को डॉक्यूमेंट को साइन करा है वो कंपनी के डायरेक्टर्स मान लिए जाए. Is that clear? And how many people are going to sign? If the issuing house is a company, then at least 2 directors have to sign it. And if the issuing house is partnership form, they are partners, then at least half of the partners shall be signing this document. Is that clear, children? I hope Deem Prospectus is now crystal clear. It should be crystal clear because we have done it at length, discussed it. Okay? Okay, good. Thank you, Tanu. I'm glad you have understood it now nicely. Bhavna is asking, first prospectus issued that shares allowed 6 months criteria. Yes. Yes, Bhavna, the 6 months criteria has to be seen. In that case, it will be deemed to be a prospectus. Now, children, again, a very lengthy section, but it is very simple. Trust me, it's very simple. If you will give all your eyes and ears to this lecture, if you keep writing down what I'm telling you, it is the simplest section of the entire chapter. Okay. Thank you, Miss Niveda. I'm glad you're enjoying the class. That's great. Let's make it a little more interesting with the contents of prospectus, section 26, new section. First thing, now contents means what all has to be included in the prospectus. Prospectus में हमें क्या चीजें include करनी है. Number 1, prospectus shall be dated and signed. It should always have a date. The prospectus should always have a date. Whatever date is written in the prospectus, that is the date which will be considered as that this is the date on which the prospectus has come. So I'm taking up the securities, I'm taking up the shares of the company. So I need to know when this prospectus has come. Okay, so the date is the date which is given over there, will be the date of the publication of this. Whatever date is written on the face of the prospectus, that is the date of the publication of prospectus. And the prospectus shall be signed. Who is going to sign the prospectus? All the directors and all the proposed directors. Say, for example, you want Mr. Ranbir Kapoor to be a director in your company in future. So Ranbir Kapoor also has to sign this prospectus because he's a proposed director. So everybody, the director who is a present director or a proposed director has to sign the prospectus. All the directors should sign the prospectus. And attorney can also sign on behalf of the directors. Prospectus number 1 shall be dated. Number 2, it shall be signed by all the directors and state such information which SEBI in consultation with CG requires. So whatever SEBI has given the rules and regulations, Security and Exchange Board of India has asked you to specify in consultation with central government, all that material should be included in your prospectus. They have not told you what all. They have only told you all the information which SEBI in consultation with central government. Kitna simple hai. You don't have to learn what all information. You simply have to learn whatever SEBI is telling you. Because SEBI is the bigger body. It is regulating you. Prospectus has come up. Not just Companies Act. SEBI is also now going to be followed. All the rules and regulations of SEBI needs to be complied. Number 3, a declaration has to be given. Sorry, this is number 3. So all the reports and the financial information to be given, what all reports and financial information you will be given in the prospectus, that has been specified by SEBI in consultation with central government. So number 1, short notes, prospectus shall be dated. Number 2, shall be signed. Who all is going to sign the prospectus? Tell me quickly in the comments. Directors and proposed directors. Very good. Then all the reports and financial information as specified by whom? As specified by SEBI in consultation with CG. Yes, ban gaye aapke brief notes along with this. So reports and financial institution. And then a declaration has to be given. Now this declaration is very important. Declaration means declare karna. I'm declaring, I'm a company, I'm declaring that I've complied with all the provisions of this act. So I'm not doing any fault. I'm not doing anything wrong. Whatever is written in the Companies Act, whatever SEBI has asked me, I'm complying with all those things. So declaration of compliance has been done of the act has to be given. And a statement has to be given. Now, what is the statement, ma'am? Statement has to be given that no contravention has been done. No contravention means no contravention. No, nothing in the prospectus contains contrary to the Companies Act, Securities Contract Act, Securities and Exchange Board of India, rules and regulations made under these three acts. So what three acts we're going to follow when we are giving this share offering the securities to the public? Companies Act, which we are already doing, and the rules along with that. Securities Contract Act, because we are offering the securities now. We have done the definition of securities. So Securities Contract Act to banta hai. And SEBI is anyways there. SEBI ke full form, Securities and Exchange Board of India. So these three parties, these three acts have been properly complied with. We have not done any contravention. While making the prospectus, we have checked all these provisions have been followed properly or not. This is the company has to include in this prospectus. So what are the 5 important things we have discussed? Prospectus shall be dated. Prospectus shall be signed by all the directors of the company and proposed directors. Prospectus shall include all the reportsmen and financial information which the company, SEBI along with CG has informed you. Company will give a declaration that compliance has been done as per the provisions of the Act, and a statement has to be given that no contravention has been done with the Companies Act, Securities Contract Regulation Act, Securities and Exchange Board of India, along with the rules and regulations paper. Have you written this? These are basic contents of prospectus, which I have written out brief summary for all of you. Abhi, there is still the task. Company shall submit the reports. Company shall submit the reports and financial information as required by SEBI and CG, else follow SEBI rules and regulations and give declarations. So the companies where SEBI and CG has told you that you have to follow SEBI and CG, there you have to follow all of them. Otherwise, where the CG is silent, you simply have to follow the SEBI regulations. Whatever declaration and statement has to be given by SEBI, you have to follow those declarations. Is that clear? Now comes your 6th point, that is expert. 5 points you have written with me. Now this in your notes. 6th point. Who is an expert? First of all, definition of expert. Quickly, test of chapter number 1, preliminary. We have already done who is an expert. If I have taken a certification from an engineer, can I call him an expert as per Companies Act? Tell me. Tell me, children, who is an expert? I'm waiting for the definition to come from your side. Can an engineer be called an expert? Miss Sanya, for Dean Prospectus, the company is just trying to take the help of the issuing house. Company is trying to follow an escape route. That if I am going to issue a prospectus anyway, section 26 content, they already know that you have to follow it. So they approach the intermediaries in order to avoid all the hassles of, following the SEBI guidelines and everything. So they take help from the issuing house. Now, issuing house is going to take care of all the matters of this, but the document that they're using shall be to be the prospectus. Very good. All of you have given the correct answer. Bala Murugan, Shruti, Mehek, Priti, Ranjita, Divya, Pallavi, Nanda, Tejaswin, Tanu. Okay, that's wonderful. CACS, Advocate, Engineer, Value, and everything you have included. Yes, ma'am. Afsal Akram says, Afsal Akram Sheikh. Okay, he's here in the Zoom also. Dama Sai Charan, very good. Any person issuing certificate under law. Not any person, you have to specify those persons. So who are those persons? Engineer, valuer, CA, CS, cost accountant, and any other person who has the power to issue the certificate for law for the time being in force. So all these people are considered to be an expert. So remember, in case of incorporation of a company also, we were taking declaration from directors, we were taking statements. Similarly, in prospectus also, you can include a statement of expert only if these following conditions have to be met. In your study material, the act which actually tries to tell you, it tries to tell you in a negative sense that expert statement shall not be included. Okay, shall not be included if these are the conditions. So I have actually included in a positive way that when you're going to include. So whether you learn it from that side or you learn it from the presentation, it's one and the same thing. Important thing is that you should understand the meaning of it. So section 26 subsection 1 says when prospectus is issued along with the other contents, a statement made by the expert. So expert is an engineer, valuer, CS. So sometimes we take a certification from them that yes, expert is saying everything has been complied. They are doing fair thing. Everything is fine. An expert will give the written consent on the issue of prospectus that everything has been complied. So this expert's written consent will be taken only if this expert is not engaged in the formation, promotion, or management of the company. So if you are an expert, you are a CA, and you're also engaged in forming the company, you're also a promoter of the company, then your expert statement will not be considered. So an expert statement in the prospectus will be included only if you're not engaged or interested in the formation, promotion, or management of the company. This expert has given a written consent and he should not have withdrawn the consent before delivery of the copy of prospectus to the ROC. So the copy of prospectus has to be given to the ROC and this expert has not withdrawn his consent. Say, for example, the expert gave his consent on 1st November 23 and prospectus was sent to ROC on 1st December, say suppose. So on 10th November, he has already withdrawn his consent. He said, no, I don't trust this company. I'm withdrawing my consent. I'm very afraid. So if he has withdrawn his consent before giving the delivery of copy to the ROC, then it is not a fair thing. His consent should not have been withdrawn. So ROC ke paas when the copy is going, his consent has to be filed. The written consent that you have taken from the expert, it also has to be filed. Copy of it has to be filed with the ROC. So what things you have to remember in case of an expert statement is, number one, who is an expert? So expert is a valuer, engineer, CS who is engaged in the power to issue the certificate for the law and time being enforced. This expert has given his written consent and he has not withdrawn his consent before the copy has been given to the ROC. Then only you can include this. What is this expert trying to tell you? His expert is trying to tell you that I give the consent. It says, I give the consent that this prospectus has been issued and it is complied with all the provisions of the Act. This kind of certification you have taken from the expert. This expert should not be engaged in the formation of a company. He has given you a written consent and this written consent is not withdrawn. These are the three things fulfilled. Then you can include the expert statement in the prospectus. Clear? Okay. Now, there is an exception to section 26. The cases where the first subsection that you have read, subsection 1, in which dated, signed, declaration, statement, reports we have discussed, it is not required in the following cases. When you don't need a fresh prospectus. Number one, when you're giving the shares to the existing shareholders or debenture holders. What do you call this? That means you're coming up with the rights issue. What is the meaning of rights issue? You are already giving the shares. Your existing members already know about the company. Why do you need to tell them again about the company? They have already taken up the shares in your company. They're already well aware how the company is running. They know about the financial position of the company. Now, when you're issuing the shares to the existing shareholders or debenture holders, you don't need to issue a fresh prospectus. So there are two cases in which no prospectus is required. Number one, when the prospectus is issued to the existing shareholders or debenture holders, means you're coming up with the rights issue. Or in case where the prospectus is issued related to shares and debentures, which are in all respects uniform. Uniform means same class of shares are being issued, which have already been quoted on the recognized stock exchange, having the uniform voting rights. What is this, ma'am? So you have already issued a particular class of shares. Now, again, you're coming up with another issue of shares. You're issuing same class of shares, which have already been listed on the recognized stock exchange. So when you listed those shares, you have already given the information to the stock exchange. Now the information is already there with the stock exchange. They're already listed. So if you're issuing further same class of securities having same uniform voting right. So earlier the shares were having one voting right. Now you are issuing same share with one voting right. Then no fresh prospectus is required. So there are two cases in which no fresh prospectus is required. Number one, we're issuing the prospectus to the existing members or debenture holders. That means you're coming up with a rights issue. And number two, where the prospectus is being issued relating to the shares and debentures which have already been listed on the stock exchange, and stock exchange is already aware about the information, you have already informed about them, and they're coming up with the same issue on the same uniform voting rights, then no fresh prospectus is required. Is that clear? I hope you all are with me at the same page. So we are doing contents of prospectus. We have done first 5 contents. We have understood expert statement. We have understood 7th point, when prospectus is not required to be issued. Let's move further. So dating and signing. So I have already told you the date on the prospectus shall deem to be the date of publication, whatever date is written in the prospectus. When we will be doing red herring prospectus, I will show you the copies of prospectus. I will show you where the date is written, and that date shall be the date of the prospectus. Prospectus shall not be issued unless signed. Very important point. Signed copy of prospectus has to be filed with the ROC before issuing it. So a prospectus will not be issued unless the signed copy. Who is going to sign it? All the directors of the company, ma'am. We have already answered, and the proposed directors also. Attorney can also sign on behalf of the directors. I'm going to ask you, very interesting MCQ is coming in my mind. After this point, I'm going to ask you. A prospectus shall not be issued unless a signed copy has been given to the ROC. So first you will sign the ROC copy, date it. You will give the prospectus copy to the ROC. Then only it will go for the issue to the public. It shall be signed by every director or proposed director. Duly authorized attorney can sign in representative capacity, means attorney can also sign in the basis of representation capacity on behalf of the directors. We have already done these points, but the summary was there to explain. So what is the important point over here? Filing of the document with the ROC. Before issuing the prospectus, signed copy has to be filed with the ROC. Point number 7, you should have all written. Point number 7, we did the exceptions. Point number 8, if you're making the notes, signed copy of the prospectus shall be filed with the ROC. Now, disclosure on the face of prospectus. What all needs to be disclosed on the face of the prospectus? So basically on the front pages of the prospectus, following things should be mentioned clearly. Number 1, that the copy of prospectus has been delivered and filed with the ROC. And number 2, all the documents and statements which are attached shall be specified. Whatever documents and statements you're going to attach with the prospectus, you shall specify all that list of documents, and you should specifically tell them on the face of the prospectus that the copy of this prospectus has already been delivered and filed with the ROC. Is that clear? Point number 9, current affairs for 9 point. We are not doing as per subsections, although you can refer. These are all summary point subsections given in the study material also. I'll show you from there as well. But I have briefly made the notes for you so that it becomes easy for you to learn. So I hope it's clear now how you are, what all signed copy has to be given to the ROC, and disclosure on the face. A signed copy has been filed with ROC, and all the documents, list of documents, statements which are attached to the prospectus. And a very important point. The last point, 10th point, you can mark it. Very, very important. Prospectus shall be valid only for 90 days from the date on which it is delivered to ROC. So if you have given the copy to the ROC on 1st October 23, so from 1st October till 90 days, so 31 days of October, 30 days of November, you'll count, and then balance days of December, you'll count till that last day of December. 90 days, the copy of prospectus will remain valid. Hence, fresh prospectus has to be issued. If you have 90 days have passed, if you have issued to the public within 90 days after filing with ROC, then it's fine. Else, it will not be a valid prospectus. You will again have to do all the compliance. So MCQ can come. Within how many days the prospectus shall be issued after filing with ROC? Within 90 days. So examiner will ask you, within 60 days, within 30 days, you have done so much information and incorporation of company you must have done for 60 days, 30 days, registered office, everything. Yeah? So this 90 days have come up. So you have to retain this information. But when we are doing it prospectus, when you have done it, all the sections, underline these points in your notes, colored beautiful notes you all should be making. This is the time when you should be doing all the hard work of making notes to you. Jitna aap likhenge, the more and more you do writing practice, it is for your reference. You are going to refer it. You will be at ease later on. So it's just a quick reference. Later on, you just have to flip the pages. And law always get learned very easily by making notes, by making your own handwritten notes. You can refer to my PPT, you can refer to the study material, but try forming a habit of writing it down so that it becomes easy for you to do a revision. So within how many days prospectus shall be issued? Within 90 days after filing with the ROC, prospectus shall be issued. So this is your brief summary, which is given in the study also. Your date is your date of publication. Signing can be done by directors, proposed director. MCQ क्या आएगा? Can attorney sign? Yes, attorney can also sign on behalf of the directors. Information under 26(1) means all the information which SEBIs require, all the reports which SEBI require. When will you include expert's report? He shall not be engaged in the formation of the company. He has given a written consent and he has not withdrawn a written consent. All these above points have to be mentioned in the prospectus. And what does cover page means? The face of the prospectus. It shall include two things. Tell me what two things have to be included on the face of prospectus. You tell me. A cover page will include what two things? Okay, let's keep learning also side by side. Yes, Neha, experts are those who are having high level of knowledge. So CS, yes, that's why we call it. Yes, you can call it FPO also, correct, Vaishnavi and Tejaswin. Yes, Ms. Bhavna, same voting rights means earlier they were given one share, one voting right. Now also you're giving the same voting right. They're not increasing. Vidushi, absolutely correct. So same uniform shares and debentures which have been issued earlier and same category. So Tanu is saying list of documents. Pallavi is saying list of documents. Why you forgot a copy to be sent with the ROC? That is also has to be informed. So please remember, children, two things have to be disclosed on the face of prospectus. Number one, a copy of prospectus that has been filed with ROC. And number two, list of all the documents that are attached to the prospectus. Penalty. So the first penalty of this chapter. Today we just have one penalty in this chapter. If you try to contravene section 26, the penalty for the company will be rupees 50,000 up till rupees. So the best part is it's the same penalty. Easiest penalty, you to learn kar hi lena. So section 26, because you're learning all the content, so 10 points you've learned, 11th point is put down in a notes mein. Contravention of section 26, if you contravene any of the provision, say for example, there is a CA who is part of your company, who is involved in the formation of company, you took his expert statement. Can you include his expert statement? No, because expert should not be engaged in the formation of company. So you have contravened section 26. Now the company will be liable to fine 50,000, which can go up to 3 lakh. And any person who is knowingly issuing a prospectus, being a party to it, any officer in default, he will also be liable to a fine of 50,000, and the fine can go up till rupees 3 lakh. All right. Any doubts so far? I hope this is clear. Dating and signing, Nanda, that is the contents of the prospectus. On the face of prospectus, two things are: copy has been filed with the ROC and all the list of documents. Okay? Very good. Good, Miss Pooja. Archana, very nice. All right. Mrs. Archana, so far I have taken your class for preliminary and after that I'm taking the class for prospectus. Okay? You will get all these PPTs on the portal once the lectures have ended. Okay? So any doubts in section 26? I hope section 26 is now clear to all of you. Now, that question that was coming in my mind, MCQ, I want to ask you. So, if there is a company which is issuing a prospectus through OFS and it's a deemed prospectus, then who all shall be signing that prospectus? All the directors, 3 directors, or 5 directors of the company, or the proposed directors. So there is a company which has gone to the issuing house and they have requested them to offer their shares and sale for securities to the public. and they have included it as shall be a deemed prospectus. Who shall be signing that prospectus? 2 directors, all directors, proposed directors, or 3 directors? Miss Aditi is the first one to send the correct answer. Very good. Very good, very good, very good. So, ma'am, it's a deemed prospectus. 2 directors shall be signing it. Very good. And if I tell you that contents of section 26, who all shall be signing the directors, then majority of directors or all the directors? This is correct. All of you have answered correct. Now, second question I'm asking. So, correct. Well done. Well done. Well done. Well done. Well done. Vidushi, you said wrong. All directors, deemed prospectus, 2 directors. Okay. Daman Sai Charan has also mentioned about the partners. Had it been partners, then at least half of the partners. So that means you're learning also, huh? Next question. There is a prospectus. All the contents as per section 26, subsection 1 has been included. That prospectus shall be signed by all the directors or majority of directors. A prospectus of a company shall be signed by all directors or majority of directors. Choose one. All directors. Very good. Along with the proposed directors. Very nice, children. I hope section 23, 24, 25, 26. Any doubts in these sections so far? So can we move to section 27? Anyone having any doubts? Okay. Another MCQ question for all of you. What are the 2 cases in which the prospectus is not compulsory to issue? Prospectus is not required. What are the 2 cases? What are the 2 cases in which the prospectus, no doubt, I liked it. So many of you have written, ma'am, no doubts. It's crystal clear. So that means that is something good. Study material, maybe, but let's have a reference. So deemed prospectus we have done. This 6 months of allotment, I hope it's clear. This is your Gurutam case, which was mentioned if 50 is exceeded. These are your additional matters, okay? These are 3 things, additional matters shall be included along with section 26, subsection 1. MCQ can come on this. What all additional matters can be included? Gross amount received, net amount received, full amount received. What should be there? So net amount received has to be written as the additional matter. Signing has to be done. We have already discussed by 2 directors. So there is a true and false which is given. Matter specified under 25 subsection 3 on behalf should be in substitution. No. These are the additional matters. So very important, please understand this page number 3.10. That question has been given over here. It's very important, this question, children, that whether you are talking, these are the matters which are as a substitution. No, these are the additional matters. Along with section 26, subsection 1, these matters should also be. Now, this is one important thing since it is given, see, additional reading for better understanding. Now, this is actually your homework, but since I have a habit of doing and running through everything in the study material, so I quickly try to tell you what is this trying to tell you. It says, what is the meaning of public? So, public at large means only when you're going to the public at large, then only it shall deem to be a prospectus. The public is not restricted to public at large. It can include any section of public. So, for example, public means persons not personally known as a promoter. So, if you have written 3,000 copies which were offered for subscription and was headed private circulation only, means it was given only to certain number of gas companies. So, you have to clarify whether you're going to the public at large. If you have written for private circulation only, that means it is strictly private and confidential. Then you are giving to a selected group of people. It can be a private placement. So here the decision was taken that the offer was to a limited class. It was not less offered to the public because those persons from limited were not less than the public. So here the word private circulation means an offer to the public only, and this was a deemed prospectus. So why it is saying? Because it is to certain number of gas companies only. So you have circulated it. It is not only to a limited class, it was making the offer to the public. So at times you have given 3,000 copies of the document were offered for subscription to the shares of the company. Although it was written private circulation, but it was sent open to the company, then it is a public document, then it is a deemed prospectus. But what happened in case of Nash versus Lend? Nash applied for certain shares on the basis of document which was sent to him by Lend. So there was a person, Mr. Nash. Lend has written a letter, a document has been written which says strictly private and confidential. Now, child, if I am writing a letter to you, remember offer and acceptance. If I am giving an offer to a specific person, only that specific person can accept. Similar is the case over here. Here, the letter was written to a specific person. Lend has written the letter to Nash, and Nash applied the shares on the basis of this. This document did not contain all the material facts. Now later on he said that since it is not containing all the material facts, so liability should be occurring. I will ask for the compensation. So here the suit was dismissed. It says it's not a prospectus. Public word means it is not in general. Anything which is happening between two people or two subscribers will not comply the whole of the people. Here the point is that the offer was open to anyone who brings his money and applies. Then only it becomes a prospectus. Last line, sirf you have to underline. A private communication is not open, therefore it is not a prospectus. So what is the summary of the case where one person has written a letter to another person and he has applied the shares on the basis of it, and it is written strictly private and confidential. Here, there is no prospectus being issued to the public. It is only a private communication. It is not a prospectus. Is that clear? So that is why they have given you this illustration. Now this illustration you can read as a homework. Now you will easily understand what it is trying to tell. So this is your section 26. We have already done all these acts names. Please remember that you have to comply with Companies Act, Securities Contract Regulations, SEBI and rules and regulations when you're issuing a prospectus. So you have given me the answer. This was the correct answer. Very good. Very good. Divya, Garima, Tanu, Nanda, Vidushi, Aditi, Tejaswin, Pooja have given the correct answer. So here is your correct answer. When the prospectus is not required, if you're issuing the prospectus to existing members, if the prospectus is issued with uniform shares which were issued earlier, they were already quoted on the recognized stock exchange. Now you don't need to issue a fresh prospectus for them. So here is an example for all of you. Sarika, executive director, has to fly to Davos to attend World Economic Forum meet. While the company secretary intended to file a copy of prospectus with the registrar, Ms. Sarika authorized in writing Mr. Gautam for signing such copy. So it says filing of the copy with the prospectus is very important. You have to file the copy of prospectus with the registrar, then only you can issue the prospectus. Expert statement is also clear. I hope we can move to section 27 now. There is nothing additional over here. So this is the question. Copy of prospectus needs to be signed by majority of directors. No, false. You have already answered with this thing. All the directors duly authorized authority can also sign in the representative. We'll complete section 27. Then I'll take a small break of 5 minutes and then we will do section 28 and 29. Okay. So now, children, there is a question for all of you in the class. There is a company, it has issued a prospectus. It has taken all the contents of section 26 of section 1, all the contents, its bond statement, everything was given in the prospectus. You have told the shareholders your purpose for which you are going to invest the money. You have told your object that this is my object. I'm going to start up a company. I'll be making different malls. I'll be investing. I'll be taking the money from the public and I'm going to open up different malls in different cities. And now you have decided that I want to change my objective. Instead of malls, I will be open up IFI societies, houses. I'm going to invest the money in somewhere else. I'm trying to vary. I'm trying to change. I'm trying to bring changes in the objects which were given in the prospectus. Can I do that? People have, on the basis of that trust that Harleen ma'am's company has issued a prospectus and they told us that they're going to invest the money in a particular place. Now they're going to change their object only. Can a company make such variations? Can a company bring such changes in the prospectus? Yes or no? What do you think about it? Can we do such changes? Shruti Mahek straight away says, no, ma'am. No, we should not do it. Not allowed, na? It's not a good thing. We should not do it. Vidushi, don't worry. Private placement, section 42. Don't go into detail. We will discuss it when we do private placement. Thank you, Ms. Divya. Thank you so much for your appreciation. I'm so happy you're enjoying the class. No, ma'am, it's illegal. No, ma'am, it's not an easy task. Okay, everybody's saying no, ma'am, no, ma'am. Okay, so this was a layman's knowledge that we have shared. Now let's see what Companies Act is trying to tell you. Companies Act says, my dear students, yes, you can do such kind of variation. Number one, it says, see, strictly you should be using the money that you have taken from the public. You should strictly use it as per the terms given in the prospectus. We cannot vary any terms of the contract. I go with all of you. You are right. But Section 27 of the Companies Act says, yes, following these conditions, you can bring the changes. You have to follow certain conditions by the company. Then following those conditions, if your shareholders are consenting, if they're agreeing, then you can do this kind of change whenever you are making any variation in the object or contract of the prospectus. Is that clear? So I hope I've laid the foundation of Section 27. What we're going to discuss. We're going to discuss in this topic, can we bring any kind of changes in a prospectus? Number one, we should strictly use as per the terms which are given in the prospectus. We should use the money. Number two, if you feel that there is an important change to be brought, then Section 27 conditions needs to be followed and you can still bring in the changes in the prospectus. First important thing is prior approval by special resolution is required. Oh, ma'am, what is this word special resolution? We don't know what is special resolution. How will you know? Because we have not done the chapter management and administration so far. So just let me briefly tell you what is the meaning of special resolution. So in the chapter management and administration, where you'll be learning about the meetings of the companies. So company has different kind of meetings, AGMs, EGMs, general meeting. Shareholders come and they give their opinion on different kind of things. This is said to be resolutions. The company's resolutions are being passed. That means they're agreeing on certain things. You can, as of now, understand the consent given by the shareholders. So they're ordinary resolutions, they are special resolutions. In case of special resolutions, majority of the shareholders have to say yes to anything. Now, children, here you will understand funds, shareholders have already invested their money. So don't you think that we have to tell them, we have to take their permission if we are making any changes? So that is why SR is required in case of any variation to be brought in prospectus. SR needs to be passed because majority of the shares, special resolution means majority of the shareholders will say yes, then only such kind of change can take place in the prospectus. All right. So special resolution and the details of such resolution shall be published in newspapers. So you have to publish an advertisement has to be given in the newspaper that look, we are going to bring this kind of variations. Why you're announcing it in the newspaper? Because you want all the members of the company. Agar kisi ko nahi bhi pata hai, then also you have given it open in the newspaper, announced it to the public in front that they should come to know that this company is going to bring the changes in their terms of contract in the prospectus. Which newspapers? One in English newspaper, one in vernacular newspaper means the state in which the registered office is situated. If you're in a particular state like Maharashtra, so Marathi will be understood in that particular newspaper. If you're in Punjab, then in Punjabi, in which vernacular state, the state in which your RO is situated in that particular vernacular language. And one in English, so that English is taken to be a common language, everyone can understand. And also place this notice on the website of the company. So two things I've told you. Number one, you need to pass the SR. For SR also, board's approval will be required, which is very important. So SR needs to be passed. And for passing this SR, you will be publishing the notice in the newspapers and also on the website of the company. Point number one, SR needs to be passed. Point number two, in the newspaper you will be giving. And point number three, and also in the website. Point number three is dissenting shareholders. Dissenting means, in Hindi, you can remember, naraz. Dissenting means they're not agreeing. They are very upset you're bringing such kind of changes. You know, you have taken my money. I have taken shares in your company. Now you're changing. You were saying that you will be making malls. Now you're decided to make companies. I have decided to make houses. So I have thought some different plans. Na? That's why I invested money in your company. So I'm a dissenting shareholder. I'm not liking it. I'm feeling upset about this kind of change. So dissenting shareholders means जो shareholders नाराज हो गए हैं इस change से. They're not happy with this change. They shall be given an exit offer. So we tell them, look, don't be so upset. You can simply leave the company. You can exit. You have an exit offer. You can exit from this by the promoters or controlling as per the regulations. SEBI is giving them a chance. So exit offer can be given to the dissenting shareholders. Vishika, I will give you time. Just let me complete. Dissenting shareholders will be given an exit offer. That is, if they're not liking, they're not happy with this kind of changes, then they can exit from the company. All right. So three things are clear. Let's move forward. What is there more in this? So there must be rule 7 in this. Why this is not going? Okay. So rule 7 says, now what happens at time is, and rule 7 also will be understood. Okay. So it says that you have taken the money from the public and now that money is unutilized. There's still some money left. You have not utilized it fully and now you're bringing a variation. So it is very important that there should be certain unutilized amount. Then only you're bringing such kind of variation. So law says rule 17 tries to tell you that SR that you are passing shall be passed through postal ballot. So postal ballot means everyone can send their, even if you cannot come on the meeting, you can send your voting by the posts. So postal ballot method is allowed so that majority of the shareholders, because we need to pass the SR, so majority of the shareholders can participate in the voting. They can tell their yes or no, whether they are agreeing to this kind of variations or not. Therefore, postal ballot method is allowed. Only the SR can be done by the postal ballot method. All what are the notice that you have sent for this SR shall indicate all the purpose, object, total money, how much money you have raised, how much money you have utilized for the objectives, how much objective has been achieved, what is the unutilized amount left, what is the reason for such changes. Very important. You should tell why you were deciding to make up malls, now you've decided to make up houses. What is the reason? Why such kind of justification has to be given? Asan nahi hai itna. So as you mentioned, ma'am, it's not an easy task. Yes, it's not an easy task. But yes, you can do the changes, provided you have to go through all the entire section 27 and rule 7. So whatever variations you want to bring, whatever the risk factors are there, all these kind of things have to be mentioned, how the changes have to take place by SR, and the notice which you are sending in SR shall contain all these kind of factors. Advertisement of the notice that you're sending shall be in PAS1, published simultaneously with the dispatch of notice. So the advertisement that you have given in the newspapers and on the website, in which form, first form that we are doing in this chapter, that is PAS1. So as of now, we have just done one penalty under section 26 and the first form, that is form PAS1. How you have to remember the names of forms? Chapter's name, abbreviations. PAS means Prospectus and Allotment of Securities. So PS1 form will be used for the advertisement, which you have sent along with the special resolution for the notice. Also, the notice will be placed on the website. Dissenting shareholders shall be given the exit form. This is all your section 27. Let's have a quick recap of section 27. So shareholders, if you want to bring any kind of variations, yes, you can bring any variations in the terms of contract or prospectus. Strictly, you should follow it. You should not bring, but if it is required, it is very urgent, then yes, you can bring. You have to pass special resolution for bringing such changes. Passing the special resolution has to be done by postal ballot. So that majority of the shareholders can participate. The advertisement has to be given in the newspaper, one in English and one in vernacular. Advertisement also have to be given on the website of the company. Dissenting shareholders should be given a chance to exit. If they're not liking, they're not happy with such kind of changes, they are allowed to exit the company. All right. We will be completing section 28. Just allow me 5 minutes break, children, just to give relaxation to my throat. And then we will move to section 20. Let's take a small break. All right, students. Any doubts still here, section 27? You can ask your doubts because we'll be moving to section 28 then. I want to wind up section 28 in today's class itself. Okay. Now, section 28 tries to tell you, sometimes children, what happens? I hope we are connected. Yes. So sometimes what happens is the promoters or the shareholders of the company wants to sell their shares. They want to dilute their holdings. So instead of raising a new capital, we are not raising any new capital over here. What was new capital? In IPO and FPO, we are issuing the shares to the public. Public is giving us money. We are issuing new shares. In OFS, a director or promoters of the company, they want to sell their shares. So there is a shareholder, say for example, Mr. A, a shareholder of the company. He goes to the company and tell them that company, I want to sell my shares to the public. Can you help me in this? So company says that, okay, fine, we will sell your shares to the public. And whatever expenditure the company is going to do in this case shall be reimbursed by the shareholder. So the company member shareholder says, you sell my shares. He's using the company to sell their shares to the public. And whatever expenditures will be incurred by the company, the shareholder will reimburse them these kind of expenditures. Now, the document the company will be using in order to issue the offer the sale to the public, that document shall deem to be the, what do you think? The document through which the offer for sale is being made shall deem to be, you have to tell me. You have been listening to me since 6 p.m. Now you have to tell me. Bhavna, postal ballot, MGT chapter, we will discuss in detail over there. Dissenting Shruti and Neha, dissenting means those who have not agreed. Dissenting shareholders who are not agreeing to your changes or variation. They're not liking, they're not happy that you're changing the terms and prospectus. Yes, I'm waiting for the answer. The document through which the company is going to give this offer of sale to the public shall deem to be a deemed prospectus. Excellent. Pallavi, Mehek, Kushi, Aditi, Mr. Bala, Tanu, all of you, Tejaswin, all of you, good. So all the members of the company, now how this is going to happen? So it is not very easy to sell your shares. You have to take the board of directors approval. See, any kind of changes you're bringing in the company. So these are basically big promoters, big investors who have invested their money in the company. So board's approval is very important because directors, you cannot sell your shares without directors' approval. They are running and managing the company. They know how the objective of the company is being used, where the money has to be used, how the things are happening. So board of directors approval, number one point over here is board of directors approval is required whenever any member wants to share their shares to the public. The members who are offering their shares shall authorize the company to take steps, take all the action. So they're allowing the company, that company, please go and sell my shares to the public. I'm giving you all the opportunity. You can take all the necessary steps. Point number 3, all the expenses have to be reimbursed by the members. Who will reimburse the member expenses? Members will reimburse the. So whatever company is doing kharcha for selling your shares to the public, you will get the reimbursement from the members. And point number 4, the document that you are used for offer for sale, that is OFS, is deemed to be the prospectus. Point number 5, what shall happen? Section 26 will become applicable and liabilities under section 34 and 35 will become applicable to this document of OFS. Now, what is Rule 8 trying to tell you? Rule 8 tries to tell you that the provisions related to prospectus, following provisions shall not apply related to OFS. It says the provision, the 4 things will not be applicable to offer for sale. That is provisions related to minimum subscription and provisions related to minimum application value. Now, let's not confuse ourselves. These are actually part of section 39. When we understand allotment of securities, there is some minimum application money which you have received and minimum subscription should have come. If you have not received the minimum subscription, you refund the money in 15 days. So, this is section 39 part. So, you just have to remember that this is not applicable to OFS. Minimum subscription and minimum application value is not applicable to OFS. Provisions related to statement made by board of directors for utilization money statements. So board of directors generally, when you issue the prospectus to the public and you take the money from the public, board of directors have to prepare a utilization statement. So in OFS, you don't have to prepare utilization statement. Why? Because the money is going to the shareholders. You are selling the shares of shareholders. Now, company is not getting the money. Who will get the money? Company is acting as a mediator. They're selling the shares of the shareholders to the public. Same way in which deemed prospectus, you were having an issue and house you were selling the shares. So here you don't need a utilization statement. Board of directors do not need to make a utilization statement because the money will be given to the shareholders. And any other information which cannot be collected, and you have given the justification. So there was any other information which you cannot collect it, you cannot find the reasons for it, and you have given the justification for that, then it's okay. So these 4 things you have to remember in case of OFS. Minimum subscription is not applicable. Minimum application value is not applicable. Statement related to utilization statement of by board of directors is not required. And any other information which you cannot given and you have given the justification for that, then that is absolutely fine in case of offer for sale prospectus. And also you should tell of the name of persons bearing the cost has to be disclosed because you have to take the reimbursement from the shareholder. So you should name the person who are bearing the cost so that tomorrow you can reimburse those kind of people who have made the efforts for issuing the prospectus to the public and selling the security. Now, children, please mark down certain points in case of OFS. You please write down OFS is different from IPO and FPO. Write down OFS is different from IPO and FPO. Number 2, no new shares are issued in case of OFS. IPO में new shares are issued. Now, FPO में भी new shares are issued. In OFS, no new shares are issued. Third point, no new capital is introduced in case of OFS. No new capital is introduced in OFS. You're only changing the shareholding pattern. Earlier, I was having 100 shares. Now I'm selling my 90 shares. I'm only having 10 shares. The capital is not changed. Only the shareholding pattern is changed. And the issuing house, which is publishing the document, it is publishing it as offer for sale. It shall be to the prospectus. This is how it has to be done. Board of directors approval is required and reimbursement has to be. Is that clear? Any doubts in section 28? Because now we're going to do section 29 also. Clear? Let me just see in the bottle also if there are any doubts. Clear. Exit means to leave. Yes, Nanda. Exit means that they can leave the company. Vernacular Prachi means vernacular newspaper, the local newspaper where the language can understand the state in which the registered office is situated. Now, what is section 29 going to tell? We did section 27, rule 7. Section 28, rule 8. Section 29, Rule 9 and Rule 9A are not given in the study material, but just a small reference I will give you since it is mentioned over there. So we can just use a small reference. So now Section 29 tells you a very simple thing. Public offer of securities to be done in dematerialized. Now you simply have to listen to a story. First, there is a private company. Private company can issue the securities in physical form or demat form. There is no problem. But when we talk about public company, I told you public company listing its securities, when it is a listed public company, it has to be in demat form. It has to comply with all the regulations of SEBI. Dematerialized forms. If one is physical form, one is demat form, online forms. So unlisted public companies, how they are going to convert their shares into demat form, for them Section 29 has been used. So Section 29 simply tells you whenever you're making any public offer, please make sure that all your shares are in demat. Any class of public companies which may be prescribed issue the securities only in dematerialized form as per the provisions of Depository Act 1996 and the regulations. So if we just read Section 29, it just simply tells you this thing that you have to make the public offer. Whenever you have to make the public offer, it has to be in the demat form. How this dematerialization has to be done? It has to be done as per the provisions of Depositories Act. Depositories Act is not part of your syllabus, so you don't have to learn it. What is Depositories Act? How it has to be done. But since it was given Rule 9, 9A is given over here. In your study material, a reference has been given. So I've just tried to touch the basics of it from the extracts from the Bear Act. So Rule 9 tries to tell you any promoter of the company is making a public offer shall convert its securities. So every director, promoter, KMP of a company, whenever they want to sell unlisted public companies. So public companies already have the securities in demat form. SEBI has to be followed by them. SEBI rules are very important. They have to follow them. So listed companies will have to follow whatever SEBI says. For unlisted public companies, Section 29 is up. So it says every entire holding of the securities by promoters, directors have to be converted into demat before you offer or sell your securities. So say, for example, I'm a promoter of unlisted public company. Now I want to transfer my securities. Before transferring my securities, I have to convert it into demat. So there is a manner which has been laid down. There is a facility which is provided under Depository Act, how this demat form conversion has to be done, which is given under Rule 9A. So this is your Rule 9A. It tells you how the Rule 9A of companies, prospectus and allotment of securities rules. You can simply just understand it. For better understanding, you don't have to learn it. Okay. So the securities can be issued in demat form by unlisted public companies. How you have to do, they facilitate a process for it. I'll simply try to tell you without this presentation. So there is a facility for converting your securities into a dematerialized form. What you have to go is you have to go to the depositories. So there is DRS, that is depositories, registrar to issue and share transfer agent. These parties are going to help you to convert your securities into demat. So this facility has to be given. The company will give this facility to the shareholders, to the members, that you can pay a fees to depositories and registrar to issue and share transfer agent, and you can convert your securities into demat form. Now, when they go to DRS, there is a SIN number. There is a security ISIN number, International Security Identification Number is given to them for conversion of securities. And then they need to pay the fees to the depository. Now, twice 2 years of the amount of fees has to be paid as a security deposit whenever such kind of dematerialization has to be done. And another important thing over here is from 2nd October 2018, it has been decided that all the securities, whenever a company is trying to make any further public issue, they have to convert their securities into demat form. Then only they can go for the further public issue of securities. So from 2nd October 2018, it has become a mandate, it has become compulsory. Then whenever company wants to go for any public issue, it has to convert its existing shareholding into demat form. And this facility has to be provided by the company, that you have to follow Depositories Act 1996. DRS is over there. You have to go to the DRS. You have to give them fees. ISIN number will be given to you, allotted to you, and then entire dematerialization conversion will take place. Along with that, there is a PS6 form which has to be filed twice. It has to be filed every 6 months. You have to file and be giving the details about this kind of conversion. Another important thing was, what was the fees, security deposit that you have to give? Twice the amount has to be given as the fees. 2 years of the amount of the fees have to be given as a security deposit whenever you're looking forward for such kind of conversion. And if any shareholder feels any problem in doing such kind of conversion, going to the depository and registrar to issue, they can report it to the IEF authority, that is Investor Protection Authority, which you actually study about in detail in chapter of TIBET. Okay, so this is the provision which has been given to the unlisted companies for conversion of their shares from physical to demat. Is that clear? So they have to file PS6 form. PS6 form reference can be taken June 9A. So with this, we have completed our agenda for today. That is section 23 to section 30 I wanted to do, but we have completed till section 29 because section 30, again 31, 32, 33, we will be taking in continuation in the next class. Yes, Hardik, queries?
Good evening, ma'am. Ma'am, in this, if the unlisted company is there, then they have to follow this procedures of dematerialization. But ma'am, listed companies has already followed it. Am I correct?
Listed companies are already following SEBI guidelines. They already have to have their shares in demat.
And ma'am, this dematerialization extended form, we do not have to learn it.
Please be loud. If this dematerialization.
In dematerialization, we do not have to learn all these forms and all.
No, you don't have to learn. It was just an information because since it is given in your study material Rule 9 and 9A, I'm showing you. So that's why I've just given you a basic reference. Since we are doing the topic, so we should have the basic knowledge about this.
And ma'am, one last question. Ma'am,
yes.
Do we have to learn the case laws as well?
Case law reference you can see, but not, see, I cannot say anything which is important or unimportant, but you can just give a reading. Just that's it. Okay,
Okay,
but
ma'am.
the
Thank you,
content is important. The concept is important. Understood
Yes,
the
ma'am.
concept? With just one case law we have referred, so it is simply trying to tell you if the number of members were more than 50, then that right issue would also be kind of a deemed prospectus. That's it.
Okay. Thank you, ma'am.
I will show you also in section 29 where it is given in the study material. This we all have done. So only this much section has been given, children. You simply have to remember every company making a public offer, the issuing of securities has to be done as per Depositories Act. For unlisted, so section 1A has been inserted for unlisted companies. Any transfer of securities have been held in physical form, dematerialization has to be. Convert your shares into dematerialization form, issue them in physical securities. Issuing in dematerialization has to be done as per Depositories Act, and Rule 9A and Rule 9 have to be followed. So they have not given you in detail about Rule 9 and 9A. Since the reference has been given, that's why I have given a small brief note in my presentation so you can refer. Yes, Sai Sharan.
My doubt was regarding definition of securities. Where we have done an MCQ regarding
Loud,
that where we have done an MCQ regarding that ULIPs and then actionable crimes of an mortgage, right, ma'am? There, but the definition doesn't implies an actionable claims can be deemed as an security.
So if
And
you
at
refer
what
to
point,
there's an act written over there, Reconstruction and Net Assets Act. So it is covered under that.
okay, fine, actionable claims can also be treated as securities, right, ma'am?
Sorry?
Actionable claims can also be treated as securities.
Yes.
Okay,
All
fine.
right. Anything else, Sai Charan? Okay. Tanu also wanted to ask something. Any more queries you have, you can raise your hands now. You can speak to me if you have any queries, child. Thank you, Miss Neha PR. Thank you so much for wonderful comment. Shruti Kumari, you don't have to remember what kind of cost they are paying for that. So simply presenting shareholders, they can exit offer option is given to them in case they're not liking about the variations. Aditi is asking, we need to mention the sections and rules. So we'll try as far as possible. You can learn the sections. Rules are not very important to mention. Never ever mention a wrong section or wrong rule in the exam. If you can retain, you can remember, it's well and good. But what I have seen so far in CA Enter, your company's act is framed so beautifully. Study material has taken all the sections serial wise that while learning only, that it becomes very easy to learn the sections. So automatically you'll be able to learn. Yes, Mr. Nanda, you can use the same book. So Prachi, these are just simple forms that you can use. So there is no difference kind of forms, and you can say the PS1 is being used for advertisement, which you're giving in the notice. PS6 is being used for dematerialization or conversion you're talking about. Okay, so simple forms names you can remember. Thank you, Mr. Arun Mishra. Thank you so much. I'm so glad he has written, ma'am, you are one of the great teachers who I've met. Thank you so much. Any doubts, children? If you have any doubts, you can raise your hands, you can speak to me and ask your doubts. And if you don't have any doubts, that's wonderful. Yes, Prachi, you should not mention wrong sections. Thank you so much, Tejaswin. I'm glad you're finding it easy and understandable. And my humble request, children, whatever we have done in 2.5 hours right now, you must revise it. If it's too late now for you to sit with your books because you must be very tired, tomorrow morning, the first thing, revise whatever we have done. Once you revise the lecture you have done with the teacher, you'll never forget. And then it gets retained over. So that's a promise I'm taking from all of you before I meet you on 14th. Now we'll be meeting on 14th. We'll be doing a lot of sections because on 14th and then we have 16th class. So too much chunk will be there for you to learn on 14th and 16th. So as of now, just simply learn whatever we have done so far. All right. So I think no more doubts, and thank you for the lovely messages that you have given to me. Thank you so much and good night. Thank you so much.